Could you please clarify on the Constitution doesn't state anything on Itauke land and all other matters relating to land. Is there a reason for not being included in the proposed Constitution?
As I highlighted earlier on, that even though in the 1997 Constitution, you had the entrenched provisions. Yeah, the entrenched provisions, yeah. Now, that entrenched provision, all it basically said was that if you wanted to amend any of those entrenched laws, you had to have certain majorities in Parliament and in Senate. So, those laws, in fact, gave protection to Itauke land. Correct? Section 5 of the Native Land Trust Act. Native Land Trust Act says, native land shall not be alienated by Itauke owners, whether by sale, grant, transfer, or exchange, except to the Crown. In other words, except to the government. And shall not be charged or encumbered by Itauke owners, and any Itauke to whom any land has been transferred hereto by virtue of a native grant. So basically, even the landowners themselves are stopped from transferring the land to anybody else other than the Crown, to the government. That's what it said. Now what that 1997 Constitution said, that this law cannot be changed. Right? Cannot be changed. There are many other aspects to this, but this is one particular section I'm reading to you. Now, let's be frank. Let's go back to why this was put in. The reason why this was put in, if you look at the before independence, the thinking was that if these protections were there, but somehow the other, because people of Indian origin were larger in numbers, they might change the law and take away Itauke land. That's the bottom line. That's why it was done. That's why the Senate was created. Right? That's why you had entrenched provisions. Now, when I talk to you about Momi, in Momi you had the 1997 Constitution was there. You had this law that was there, is there. But despite this, they still went ahead and alienated the land permanently. So the reality is that it's not the flowery language and having entrenched provision in the Constitution. The reality is that the law must be adhered to, and the law already guarantees the non-permanent alienation of Itauke land. But apart from that, see, this gentleman, the former member of Parliament, was arguing on the other side. He was talking about ELTA, because you will see ELTA is an entrenched provision also. But the point is that those laws, in fact, became caught in a time warp. Now, one of the things is, like I talked about ELTA, now you have Itauke land being leased for longer periods, for commercial agricultural purposes. Lease, 50-year lease, 60-year lease, whatever. Now, those laws would not have been able to be changed if you had these entrenched provisions unless Parliament agreed to it. In terms of your safeguard regarding land, if you look at Section 27. Section 27 of the Draft Constitution talks about every person has the right not to have any interest in any property expropriated other than in accordance with the written law referred to subsection 2. This is a written law. So, nobody can come, this is the constitutional safeguard. Nobody can come along and say, okay, we're going to take away Itoke land. Because the law says you can't. If you can, there's only under certain circumstances you can. Now, the other provision, so that's one outright provision. The other provision that's been included is if you look at under the non-discriminatory provisions, section 26(3), we have also included, this is the other angle, we've also included for the first time culture. You cannot be unfairly discriminated against on the basis of culture. Now, as we know, if you look at Itoke customary laws, customary provisions, customary ownership of land, a lot of it is to do with culture. So also if somebody comes along and tries to inappropriately deal with the Itoke land, it's also an infringement of your culture. So you have two shots. One is the law that already exists, and the other one is on the basis of culture. You can argue that somehow the other my land has been affected. So they are the safeguards. In fact, those safeguards, I would argue, is a lot more stronger and better because they are under the Bill of Rights. Now, Bill of Rights is, as you know, is universal application. Whereas the entrenched provision, I think it's 187 from memory, under the 1997 Constitution, simply said that these laws are entrenched.
Just to explain that the laws of the land in the law books, we would like to see it in the Constitution, especially dealing with the case. Because the law would be, can be either changed by few lawyers or is it written there, changed by five?
No law can be changed by a few lawyers. When this Constitution comes into being and you have an elected parliament, any law, even a word, needs to be changed by Parliament. Section 43 of the draft Constitution says that the authority and power to make laws for the state is vested in Parliament and is exercised through the enactment of bills passed by Parliament and assented by the President. Nobody or person other than Parliament has authority to make any law it pleases, except under authority conferred by this Constitution or by a written law. The second part means basically, if a law says that the Minister for Environment may make regulations regarding throwing of tin cans or something, litter, that's the regulation. But in respect of any law, it has to be passed by Parliament. You see, if I could also highlight to you, by having this freedom from arbitrary expropriation, section 27 and section 26, because it's in the Bill of Rights, in the Constitution, it in fact gives you a wider coverage of application and protection of Itoke land. That's how we've done it. See, before everybody said, oh, we've got the entrenched provision, nobody can touch Itoke land. Itoke land was touched. It was touched. It was taken away. So what we are saying to you, let's not go for, what the politicians say, we put it there, it feels good, everybody feels good, lots about the whole thing. But the point is, how do you in practice implement it? That's the point. And that's what we've enshrined in the Constitution, directly in two areas, in two sections of the Constitution.
I think in the case of Mommy Bay was taken away with the idea of the economical value that it brings to the government. That is why it was taken away.
It wasn't taken away for the economical benefit of the government. Government's economic benefit is subservient to the ownership of Itoke land. That is the point. See, on one hand you're asking me about entrenched provisions. On the other hand, you're saying to me it's taken away for government's benefits. No, why should it be? If you are giving primacy to Itoke land, how come suddenly government's economic benefit comes over there? It should not.
I'm trying to do you giving Mommy Bay as an example.
Yes.
Then why I said that maybe the government was thinking of more economical value than that. And I hope you safeguarded that in this constitution.
Absolutely, that's what I'm trying to tell you. It is. It is. But you see, again, you see, no government has the right to override a protection law, even if we think it's economically beneficial. What do we want? Do we want the ownership of Ethiopia lands to be number one? Answer would be yes. So, no government can use an economical argument to take it away permanently. Lease it, yes. There's no problem. You can lease it. Half of Demerara is leased. You've got all the hotels on Ethiopia land, it's leased. They did not make it freehold. Most of the hotels in Fiji is on Ethiopia land. They did not make it freehold. The law said, because I had somebody on Thursday in Suva, said, oh, the landowners had drawn a commercial agreement. Commercial agreement cannot override the law. A commercial agreement cannot override the law. So that unfortunately had happened, but now it's protected. And in terms of the protection of the Ethiopia land, that's under Section 27, and Section 26 that captures that particular provision regarding Section 48.
Thank you very much, Sayed. With your explanation, I think we've been enlightened that Ethiopia land is much more secure from 1997 compared to this draft constitution. With your explanation.
Sorry, with my explanation?
The Ethiopia land and its laws are now much more secure than before.
Yes. Thank you.
Thank you.
Naga.
Thank you very much.